I think I always come back to the point that it doesn't matter what you do, you can still end up in a court or a tribunal facing a claim. Doesn't matter how good or bad you are, there is still a chance that you'll end up in the tribunal. And of course there are many employers who don't follow the rules and get away with it for a very long time, but eventually you get stung by a claim. The best position to be in is, of course, when you're best prepared, you've got the right arrangements in place. But once a claim comes, the difficulty for some businesses is when they've done all the right things, when they've ticked all the boxes, crossed all the T's, dotted all the I's, done all the right things, and a claim still arrives at their front door, they feel aggrieved about that. And they have a right to feel aggrieved about it, because if they've done all the right things, shouldn't that mean that they're not going to get sued? Well, it doesn't mean that. So when I think about some case examples, one in particular was an unfair dismissal case that I had a call from a client who was a director for a business, and that business had gone into liquidation. The director had no control over that. Wasn't her fault. It was poorly run before by the previous manager, and she'd taken it over when it was on its last legs and had to put it into liquidation. That meant that a number of the employees walked out without some of their entitlements, and you know, she had done all the right things. She'd done her best to try and keep the business afloat. One of the employees went off and commenced an unfair dismissal claim because she had lost her job as a result. That unfair dismissal claim ran on its own and took on a life of its own without anyone opposing the claim, because the company was in liquidation. What really should have happened is someone should have stepped in and informed the commission that the company was in liquidation. They didn't. And a judgment came down against the company. Now, that wasn't a problem for a company that's already in liquidation. The judgment's questionable in terms of its enforceability. What the employee then attempted to do was, that employee, who was also confused and didn't understand what she was doing, took the judgment from the Fair Work Commission to the Federal Circuit Court, and at the Federal Circuit Court put on an application to join the director as a party to the proceedings and tried to make her responsible for the unfair dismissal result, which was a full 26 weeks' pay. Of course, the director hadn't had any deliberate hand in terminating the employment of the employee who was aggrieved, and in fact she'd done the right thing by putting the business into liquidation, so it wasn't wasn't trading while it was insolvent. That employee, that client of mine, then had to go down to the Fair Work Commission and defend that case. And it was at that stage that she needed to have legal representation. I got involved, and of course we got her out of it. And it was a good result. But do you think she felt good about the result? No, because she was $10,000 behind in legal fees, which was pretty good for how much work we did on it. But nonetheless, it was cold comfort for her that she was $10,000 in legal fees and she'd done all the right things. Now, if she'd had insurance in place at the time, and she'd had all the right arrangements in place, she'd had a workplace advice line to guide her through the steps earlier on, there are a range of steps at which she could have saved herself these problems. She had have had a workplace advice line to rely on at the front end. She could have advised the employees better and avoided a claim. If she hadn't done that, she could have relied on the firm and the insurance policy for the purposes of being defended legally, having a successful legal case as she had, but also having her legal costs paid for.